immigration lawyer with the law offices of Anna Danielian, and I hope I'm pronouncing your name correctly. Just correct
More or
me.
less, it's good enough.
Okay, thank you. Anna's expertise includes work with humanitarian visas, such as VAWA. The VAWA is the Violence Against Women's Act, asylum, but today we are focusing on the new law PIP, which is parole in place. This may sound complicated for many people because this is a new law that just came in place. I brought you here to explain maybe a little bit because I know this is complex. Every case can be different. Could you explain what the parole in place is and how it benefits spouses of U.S. citizens?
Yes, I will be happy to do that. Parole in place is basically a new relief that just went into effect on August 19, 2024. And yes, indeed, it already been causing a lot of confusion among those who may or may not qualify. So it's a relief similar to temporary protected status or maybe DACA, like some of the requirements are very close. So it is not necessarily the legalization yet, like meaning it's not your permanent residency, but it could become a path to residency. So at this point, it's just a protection from deportation. And it's a relief that it will also provide to qualified candidates with the employment authorization. So it's a good thing that they can, kind of get out of the shadows. Usually what happens when a spouse that entered without inspection is married to a U.S. citizen, the normal process is that they have to apply for the I-130 family petition. Then they have to wait for the approval. And then because that person is not adjustable due to their method of entry, they have to file another relief for a waiver of grounds of inadmissibility and wait until its approval, which could be a couple of years. And then that person has to leave the United States and return through U.S. interview at the U.S. Consulate, which, as you understand, a lot of people try to avoid doing. A lot of people who lived here for a long time without authorization, they actually very apprehensive about leaving the United States in the hopes that they will be given the permission to return. This law will help them to stay with their family, right? That's why it appears in the act, helping families stay together. So they will avoid deportation and they will even avoid the interview at the consulate and very likely would be able to stay in the United States and in the future adjust their status. But, not every spouse of a U.S. citizen that entered the United States illegally can apply.
Well, at least there is hope for many families that they are afraid to be separated, right? And they have through this the opportunity to be together without being afraid of being deported. And also with you, Anna, because I know that you are an experienced attorney in immigration. I know that you are going to be at every step of the way with them in this process. So there is nothing to be afraid. They should have a consultation with you. Just to clarify, who is eligible to apply for parole in place, PIP,
Yes.
under this program?
Yes, so there is a qualifying criteria for spouses of U.S. citizens as well as stepchildren of U.S. citizens. But of course, they have to qualify under certain criteria. So for spouses of U.S. citizens, they have to be in the country, again, without admission or parole as of June 17, 2014, and they have to be married in a valid marriage with a U.S. citizen as of June 17, 2024. How can they prove that, right? Because they have to show that they were continuously present in the United States without any breaks from June 17, 2014 to June 17, 2024. So similar to DACA, they have to provide evidence of their continuous presence in the United States. So the USCIS mentioned that the evidence has to be reasonable, meaning that they don't have to have proof for every day that they spend in the United States, but provide reasonable documentation that can cover maybe some lengthy periods of time, right? Like it could be college papers, it could be medical papers, it could also be sworn affidavits from witnesses that could attest to this person being in the United States without going back and returning. So that's mostly what it has in mind. So you need to provide evidence as to your continuous presence in the United States. And also you have to provide documentation to the validity of your marriage. As you know, church marriage is not legally valid. This documentation is pretty straightforward. So you just provide a marriage certificate valid in the United States or actually anywhere. So those are like two basic qualifications. And then, of course, you go to the normal admissibility issues. Of course, if you have some serious crimes, like felonies or even DUI, it will disqualify you from filing for this relief. And obviously, generally, you should not be a threat to US security or the public. So any kind of like acts of disorder or, like some kind of security issues, they will disqualify you from filing.
Thank you so much for explaining. Actually, you expanded a lot on that, so people can have more information. Now, how important it is for eligible individuals to act quickly in applying for the PIP?
Yeah, I think it's very, very important that they apply as soon as possible. First of all, well, because of the great relief that it may provide you with, right? And also, this is something that is working right now. And I have to say, the application can be filed only online, and the system crashes all the time. But that's just about technical difficulties. We have very important elections coming up in November, and with the possible change in the White House, I mean, it's very possible that this law will be challenged by some court, or could be just taken down by a new president. They can email me at anna.danielian@gmail.com. So it's my first name dot last name at Gmail. And they can also find me online and, contact me through my website by messaging me. And anyway, I think it would be pretty easy. The important thing is actually to remember that people themselves can, in a way, do a screening, right, of their qualifications at the baseline. So like, let's say if they were not here as of June 17, 2014, they're disqualified. If they're not married to US citizens, they're disqualified. Also, if they entered with a visa at some point, applied for asylum, and then they are under final order of deportation, they're disqualified. So those things, because what we talked about at the beginning about the confusion, so a lot of people who find themselves illegal, I mean, meaning without, their authorized period of time has passed, they think that somehow it may qualify them for applying for this relief, but the criteria is actually very strict and very precise. So it's very easy to do self-screen at the baseline. And then, of course, if there are some kind of, variations on the requested scenario, then of course they can contact an attorney and discuss the specifics.
Thank you so much, Anna. Well, it was such a pleasure to see you, to have you today, to clarify about this important new law as an immigration attorney that you are. And I'm just so grateful for you. Whoever needs your help, I know that they are in good hands because you are a professional. I have experience on that. I can attest to that you are such an experienced attorney. You are knowledgeable. You really care for the people. Whoever applies, you really care for their situation. So I am so grateful for you.
Thank you, Luz. Thank you.
Okay.
Always a pleasure to talk to you.
Thank you.